All right, good afternoon.
Good afternoon, everyone.
I've got myself and Susanna here today, and we're going to talk about estate administration issues, sort of a potpourri, but starting with probably one of the most important aspects of any administration is walking through with our clients the whole concept of what they have to do and what they don't have to do. Can they delegate steps in the process, and who has to do it, and on what basis can you do it? And I guess at the end of the day, the hard and fast rule sort of that I go by is that you can delegate at the high level, you can delegate administrative tasks. But what does that mean from a tangible, active level when we're administering an estate? So Susanna, if we could start off with just a general, your observations just in terms of the question of delegation and estate administration, and then we'll talk about some of the parameters.
Sure, Ian. I mean, we want to keep in mind that the job of an estate trustee can be quite complicated. I know we always talk about simple estates and complicated estates, but not every estate is going to be a simple one. And if there's only one executor, it may be particularly onerous on that individual, depending on the size and the complexity of the estate. So that, coupled with the fact that there's this expectation out there that the estate will be wound up in a year, the executor's year, puts a big onus on the estate trustee to administer as promptly and as quickly as they can in the circumstances. Now, back to your comment about, this general rule that you can't delegate, decision-making and specific substantive functions to someone. You certainly can delegate the administrative stuff. And we see the cases talk a lot about delegation as a result of the fact that this isn't an easy job for someone to take on. And so those responsibilities can be delegated in certain circumstances. In others, they shouldn't be, because of course, estate trustees are fiduciaries, and that office carries with it this duty to act, personally. So as we talk about some of these exceptions or how we might be able to have these instances where we can delegate, I think it'll help a little bit in our discussions.
Okay, so just a reminder, just to mute and turn off your screens, that'd be great. All right, so there is, of course, a growing body of case law that's referring to estate trustees and executors delegating some of the responsibilities to third parties. And maybe, Susanna, what we can start to look at is some of the contradictions to the general rule that an estate trustee cannot delegate within the confines of the description you've provided, and maybe look at some of the legislation.
Yeah. And there are a variety of circumstances where an estate trustee actually can lawfully delegate. And we want to explore some of those things, starting with, of course, where the delegation is permitted by the legislation itself. So we know that there are several sections of the Trustee Act that expressly will permit a trustee or an estate trustee to delegate the authority to an agent, but only under specific circumstances. So Section 20, for example, permits a trustee to appoint a solicitor to receive and discharge money or valuable consideration or property that's receivable by a trustee. So in that case, a trustee can delegate that function to a solicitor. And then the second instance where that can happen is where a bank manager or a branch bank manager or even a solicitor is receiving or discharging money that's otherwise payable to the trustee. So in those two limited circumstances, Section 20 of the Trustee Act says those kinds of situations is permissible to delegate.
And the other area that the delegation of authority really, it seems to me, is important from the Trustee Act perspective is Section 27. And 27.1 permits a trustee to authorize an agent to invest trust property to the extent that a prudent investor would. And so there's two parts to that, of course. There's the ability for an executor or trustee to pass the role of, and it's a substantive role of investment to someone else. And then secondly, the confines of that investment are governed by the prudent investor rule.
And of course, in that situation, the legislation requires that the agent actually prepares a satisfactory written plan or a strategy that complies with the legislation. So that is something that's going to govern that whole delegation. And, in addition to having this written plan about how things are going to be invested, there's got to be regular check-ins with the trustee and the agent to make sure that that plan is being followed. So pretty stringent and limited opportunities to delegate by virtue of just the Trustee Act.
And it comes back to often the important thing about, which is a really crucial role of all the trustees, is to document. And that the legislation actually under section 27(1) codifies the expectation of documentation. So I see that as a crucial element of doing it properly. Susanna, what about other aspects? What other authority can you look to allow us to give us some parameters of delegation?
Well, we always tell everyone, start by reading the will and start by reading the trust. You really want to look at the instrument itself that appoints the trustee to see if there is a specific provision that allows for delegation and in what circumstances. So we know, of course, that a trustee can delegate to a third party when the testator expressly authorizes the delegation, either in a will or in a trust. We know that there is, of course, some controversy in terms of how much you can delegate or what that nature of delegation is. So it really is advisable for the estate trustee to limit, and for the testator to limit the kinds of things that they're authorizing, because notwithstanding that they could be authorized by the instrument, they might have some difficulties in the actual implementation of that delegation, ultimately, if someone were to complain. So, we try to be as cautious as possible when we're figuring out what kinds of things we want to delegate and to whom, and, in what circumstances that might be permissible.
And I always look at this sort of the delegation permitted under the testamentary instrument as an easy illustration is that you cannot delegate a fiduciary duty. And what does that mean? Well, you have a fiduciary obligation that's a fiduciary duty to account. So yes, you can, of course, delegate to someone to monitor that, to manage it, to deal with the vouchers, organize the vouchers and all that. But the ultimate obligation to account, you cannot delegate away. And that's just an illustration of what it means, in my view anyway, what a fiduciary delegation is not permitted. So what are some of the what other sort of elements of delegation do you want to consider, Susanna, in terms of beyond the legislation and beyond the testamentary instrument?
Well, certainly the cases talk about the fact that, they call it a common business practice kind of delegation. So we see instances where if it's common in practice for someone to delegate something like managing an estate asset or an estate administration, there are opportunities where that particular power or that duty, and it's always those kinds of considerations that are taken into mind, that we may be able to delegate. So historically, we know estate trustees have been able to delegate to lawyers, to accountants, to real estate agents, to stockbrokers. And so in those cases, we know that, it's common to do that and it's been accepted. So when we're in these situations, a trustee can only delegate to an agent the kind of work that they actually usually perform. So, if a lawyer is commonly acting as in doing certain things, then that kind of stuff delegated to the lawyer or to the real estate agent. And so we're looking to having the right person being delegated to, in a sense.
So one of the cases that have sort of teased these out have considered as when you have a corporation, and to what extent can you delegate the operation of the corporation, the day-to-day operations of the corporation? And that's where, again, it comes back to this principle of, it's like an elastic band. Sometimes you over delegate and you break the elastic band. With a corporation, what are some of your thoughts in terms of how we will want to manage the delegation of any steps in the administration of the corporation itself within an asset of the estate?
Well, we've got some strong case law to guide us in that situation, Ian. And for instance, we've got this decision of 2197800 Ontario Limited versus Cardigan Corporation. And there, the judge specifically held that it was entirely appropriate for a corporate estate trustee to retain an expert to assist with managing the business that was owned by the estate, and to delegate actually the decision-making process regarding the corporation to that expert. So in terms of the elastic band, we see a delegation by a corporate trustee of something that we would have perhaps expected the corporate trustee to have the expertise to deal with, and yet they were authorized and permitted to retain an expert to assist with that. So that was, some really good guidance that we got from our Ontario court just recently in terms of that authority to delegate.
And of course, the site for that, if you want to follow that, the probator that we publish monthly is our newsletter. It's in volume 30 in the March 2024 probator that Susanna published. Okay, so what's beyond the delegation of what is common practice? What other sorts of delegation do we want to consider that might be within the parameters of a properly delegated administration step?
I think one of the ones that sort of comes to mind is when we have the actual consent of the beneficiaries. If there's a situation where we're looking to delegate and everyone has accepted that and agreed to it, then we'll see cases where if they later change their minds or they later want to complain about the fact that there was this delegation and an expense associated with it, because that's usually what brings upon the complaints is like if they've got to pay for it, then in those cases, we've seen the courts actually say, look, you consented to it earlier, you can't renege on that now. And that individual who was, acting as an agent and assisting with the administration is going to get paid. And it's not necessarily going to reduce the quantum of compensation that the executor would otherwise be entitled to. So, interesting in that sense, because I do think it's right that they should be held by their decisions and not be allowed to, change their mind afterwards once they've already had the benefit of the actual administration.
Yeah, and again, just to remind people, there's some people that haven't muted it. It's kind of, we're getting some feedback. If you could just check your channels and make sure you're muted. The other, we're just getting a little feedback. I don't know if Michaela or
I'm looking for a Samsung replacement cartridge. I don't see any over there in the shop.
Samsung? For the game?
did we,
Yeah.
can you,
Oh, no, we don't.
Michaela, are we able to just mute
Bought a Samsung machine from
Yeah, Samsung game.
Algo.
someone
I don't
who's
see
kind
any
of
there.
writing
No, I
us
don't
here?
think they do. That's the thing. I know HP brother.
Mark, I think it's you that's not muted, if you wouldn't mind.
We have
No.
Canon.
No, I
HP
know.
brothers.
Okay, thank you.
It's toner. Is it a toner?
Toner,
Yeah. Okay.
you think you got that? Yeah,
Or
well,
delegate.
because you sold the
Mark?
machine. I don't know if you still sell it, but. So I'm
Uh,
just looking to a podcast while.
Is there anybody on
Oh,
the
there it is.
east
Right in
state
front of
side?
me. There you go. Look, a whole bunch of them right here. This is the one I
I don't
need.
know how to do this. Sorry, guys. This
sorry.
is not good.
Let's see, I have it on a piece of paper, which is somewhere in
Mark,
my pocket. If I know what you have at the shelf, I can look. Here, I got the paper, so this is good. It's a MLT D111 for that machine.
Sorry about this.
M2070.
Mark, you're not muted and you're,
Well, it's not a multicolor one, it's
Oh,
all
Do
black.
you have the number of your machine?
Yeah, M2070 FW.
yeah, sorry about this. Mark, maybe you could mute your
Yeah.
microphone, please. Mark, can you please mute your microphone? You're overriding the podcast. I don't know, Mark, are you there? Mark, there we go. All right, that's a little better. Okay, so we had a little distraction there. So we're coming back to this. We're talking about don't delegate or be careful to delegate. What is the consequence of improper delegation? And what is the impact of that decision? And then I also want to talk a little bit about some of the trends in delegation. But let's start with, what if we do it wrong? What is the impact?
I guess the concern really is just the exposure to liability, to criticism at the end of the day for having improperly delegated to someone. And we always, in the course of acting as a fiduciary, want to make sure that we're not going to get criticized and that we're not going to be, found in some kind of breach of trust situation. So, we're expected to, when we do delegate, we're expected to choose our agents with care and to assign work to that agent that's in keeping with their expertise. We are going to be required to supervise their work and to ensure that they deal with the trust property properly. And that, if they're not, then we also have an obligation to terminate that delegation and bring it to an end. And if we're doing that and we're documenting our decision-making and doing, making our very best efforts, then we should be okay. If we're not and we're held accountable, then that concern about personal liability always comes and rears its head to the top.
Yeah, absolutely. And that's the exposure is personal. Okay, just for fun and also I think it's worth looking at trends in terms of delegation going forward and just some of the opportunities that we're seeing out there, because we've had some pretty innovative thinking in Ontario in the last few years from the Attorney General on some legislative changes, and we've got Professor Oosterhoff, who has been trumpeting the changes to the Trustee Act to address some of the failings of delegation and the delineation that isn't quite as clear as it should be. What are some of the trends that you're seeing, Susanna, around Ontario, outside of Ontario, with regard to this, and what can we learn from it?
Yeah, I mean, in 2012, the Uniform Law Conference of Canada actually released the Uniform Trustee Act, which endorses the inclusion of a much broader kind of delegation for trustees. So we're seeing, sort of forward thinking in the sense that we're realizing that, the delegation of duties is an important one for estate trustees in certain situations. And so Section 47 of this Uniform Trustee Act actually permits trustees to appoint an agent to exercise any power or perform any duty in the administration of a trust, as long as that appointment is reasonable and prudent and keeping in recognition of the fiduciary duties ultimately. So in light of that fact that these are fiduciaries, they're not actually going to be permitted to appoint an agent to exercise the discretion to distribute or transfer trust property. So seeing a broadening of the kinds of things that could be delegated, but recognizing that there's a hard stop in the sense that, the ultimate decision-making and the ultimate fiduciary responsibilities with that estate trustee or that trustee.
Another aspect of the Uniform Act that I always thought was interesting too is the ability, it's recommending that, or it provides for the ability to put in a substitute trustee to operate via a power of attorney for up to a maximum of 12 months. So you've got maybe a short-term incapacity situation, or a trustee that isn't going to be, has gone away for 3 months or something like that, scenarios that in a busy world can happen. You can pick a trustee that is going to have maybe a blip through their attendance of it, and at the same time have the substitute trustee in. I mean, it's a practical suggestion in the legislation, and one that I think has a lot of legs, but we're going to keep working on the Attorney General here to keep paying attention to that provision as well.
Well, it certainly makes sense because, you're avoiding an actual removal of a trustee, a requirement of an accounting, and then a replacement of the trustee, and starting the wheels all in motion. If there is a gap and it's, there's a legitimate reason for it, it does make sense to be able to fill that temporary period of time with someone who's, hopefully equally suited for the job.
I totally agree. And I guess another one is that we had to watch British Columbia and Alberta get way ahead of us in the estates and trust area legislatively for some time. What's happening out west with regard to some of the other provinces that are dealing with some of the more innovative aspects of delegation?
Well, we just talked about, the use of a power of attorney to delegate the exercise of powers and the performance of duties. They also will allow another person to act as a temporary trustee, so without exercising a power of attorney, just appointing another individual, and also appointing agents to exercise powers or duties, including administrative functions related to the trust, although again, they can't exercise any discretion to distribute or transfer trust property. So just opening up those alternative situations for certain periods of time if need be.
And of course, Alberta and New Brunswick have both embraced many of these innovative aspects of the legislation. Alberta in particular, in 2023, has amended their legislation to accommodate for more reasonable consideration of delegation. So it's happening, it's out there, and it's something to keep in mind. And it'll also give us some further parameters going forward. All right, we've got the goal for today was to cover a few administration issues as much as we can in terms of topics. And if we run out, we'll do more in their next webinar. But the next one, I just because I ran into this recently, and a client asked me about it, and it was sort of a unique situation, but one that you do see from time to time. And these are just going to take some one-off topics, but the situation where you're booking travel using bereavement airfare, and what happens with using what kind of resources are available to the consumer in that regard. So someone has passed away and you're needing to use the benefit of bereavement airfare.
Yeah, this situation can arise in, a case where, of course, someone has passed away, or if there's an imminent death of a member of the family. In these situations, we see airlines will offer a reduced or discounted fare in order to get people, last minute to their loved ones under these circumstances. The fares typically only apply to immediate family members who are affected by that individual. So like, a spouse, parents, children, siblings, legal guardians. And when the requirements are met, then we're seeing a situation where you could get a reduced airfare. Now, the difficulty, of course, is when the requirements are met and how are the requirements met. And I always kind of struggle with this just personally because I find it very hard to believe that when you're dealing with the panic of trying to get to a loved one in either the situation or either situation, actually thinking about, a discounted airfare just wouldn't be top of the mind. Reading the rules and the regulations in terms of how to get it may not be. And, something that can be an impediment to actually being able to benefit from the reduced airfare if you don't do it right.
Sure. So there is some debate of whether bereavement airfares are even worth it.
Just because of that, right?
Yeah.
Because, if you're just panicking and you're getting a flight just so you can get there and you come back and you say, okay, now I want to try to collect, a reduction in my airfare, you may see a difficulty with that, depending on each airline has its own policies. And we saw that particularly in the decision of Moffat and Air Canada, which was actually reported by the Globe and Mail. And it was an interesting case where exactly that happened. Someone had purchased a ticket. When they were in the process of purchasing it, they talked to a chat bot on the Air Canada website. And the chat bot told them that, purchase a ticket. When you come back, submit your ticket, submit proof of in this case, I believe it was a death, prove that someone had passed away, and you'll get a refund for the reduction in the airfare. And Air Canada, when that individual came back, said, no, you didn't follow our policy. You should have done all of this in advance. You hadn't gotten it authorized. And so you are not going to be able to benefit, and you're not going to get any money back ultimately.
And the chat box was a little too chatty, it turns out.
Fortunately, though, the court held that, look, this chat box was on the Air Canada website. It's an Air Canada product, and they're going to be bound by what their chat was telling people. And so the individual, after, a long and expensive flight, as you can imagine, ultimately was successful. But, the last thing you want to be doing after you're already grieving or bereaving these kinds of situations is to have to fight even more for, something that should have been available earlier.
Absolutely. All right. And then last bit of time we've got, I wanted to just cover family burial plots. Again, this is all about me, and I've been in the middle of one of these debates right now. What are interment rights all about, and what kind of expectations can the clients have with regard to them, where the testator wishes to bury burial wishes are amongst the personal considerations in an estate planning. It can be an extraordinarily difficult piece of the planning and the administration later.
Oh, absolutely. And I too am just dealing with one right now where, the question is, how do we deal with the burial plot that's part of an estate, not specifically bequeathed in the will? And we're just having difficulties figuring out what happens. Easiest one, of course, is if you've got a family plot and there's, not enough plots available for the individuals who are ultimately going to be entitled, because these family plots are estate assets. But, if there's only one plot and 5 people, it's going to be a little bit difficult to figure out how to share that ultimately.
And it's also difficult to determine the asset itself, who has the asset and who owns the asset. You can get, and certainly you can get situations where there is lots of space still left. How do you get permission to get into the plot? And of course, in those situations, ownership of the burial plot is always something to investigate. And then secondly, it's consent of the living beneficiaries, living relatives that you have to seek out.
And you're dealing with cemeteries, and things can change. You're ultimately looking for paperwork, proof of that ownership. And you're also dealing with cemeteries' policies and their procedures. You know, it's been a plot that was purchased many years ago and the paperwork's no longer available. The cemetery somehow may not have the paperwork available. It can become very contentious, as you can imagine, particularly because it's such a sensitive issue for many people.
Sure, and it can be time sensitive too. So what's some of the case law that has been sort of bantied around to give us some direction in terms of how we can deal with these?
Well, we've got the decision in Smith and Cataraqui Cemetery Company, which was an Ontario court decision that held that the interment rights are actually inherited lineally, and they're gifted equally to the testator's children upon their death if there's no actual provision for it in the will. So, you know, in that case, we're getting a little bit of guidance in terms of what happens to those particular assets. But, you know, gets a little bit more complicated when perhaps those rights are held jointly with someone else. And that's the situation that I'm facing right now. It's like, you know, what happens to it? Who gets it? Does it pass by right of survivorship? Does the trustee hold it on a resulting trust for the estate? You know, there are a lot of permutations and it could go different ways depending on where those rights are held, what cemetery and who's involved.
All right, now, let's just, we have the last few minutes here, just talk about some of the other legislative parameters that we can consider looking at in terms of this issue to help guide us when we get into one of these fights.
I think you're referring to the Bereavement Authority of Ontario.
Yes,
That's actually its authority is derived from the Funeral, Burial and Cremation Services Act of 2002. And it specifically provides that the owners of a family plot are entitled to receive a certificate of interment rights. So that gives them the actual authorization of ownership or recognition of ownership. However, as you can imagine, for like rural or very old cemeteries, that record keeping again may not be available.
and of course, there's regional demographics that have to be considered, and I've certainly been involved with outside the GTA small burial sites that have their own, seems to be their own law, but something to start from is the Funeral, Burial and Cremation Services Act of Ontario. All right, well, look, those are some helpful comments for sure, Susanna. Thank you very much. And thanks everyone for joining us today. We'll continue our review of estate administration issues and topics next time we're on, and hope everyone has a wonderful weekend. Thanks a lot.
Thanks, everyone. Take care now.